Rather than, my lord, taking this matter any further, if your lordships are convinced that this is possibly a subject which may better, my lord, be left to the choice of the parliament, which is the law, my lord, if need be, I'll assist your lordship with that law. How variety of problems will be solved. And I'll give examples, my lord, which only parliament can take care of. Is recognized. It is also regulated. And then there is no absolute right to marry even today between heterosexual. Your lordships have the legislative policy so far. The legislative policy has always been in all the laws, my lord, which your lordships have come across on several occasions, has been to recognize conventional man and conventional woman. I understand difference between gender and sex, sexuality and gender, etc. We are not going into it. But all laws, my lord, whether it is criminal law, civil law, any other law, law giving protection to women, etc., they define the man and woman in the conventional sense. When this question is being debated before your lordships for the first time, I'm posing a question to myself, and my lord, based on that, appealing to your lordships, should it not go first to the parliament or the state legislature? One is sitting in on value judgment whether this should be, this is good, this is bad, this should be done, this should not be done. There is no stigma attached. The parliament has accepted their right of choice, their right of sexual preference, their right of autonomy, and that right of privacy.
Right of choice?
Autonomy, sexual autonomy in terms of sexual preference. And the privacy, that is right of intimate relationships, which your lordship said, my lord, something happening between two consenting adults in privacy. Why I say, my lord, that there is no stigma. The legislative policy is very clear now in the Transgender Act, where the term transgender is very widely defined to include, my lord, all shades and all spectrums of what we call LGBTQ+. The Transgender Act is the response of the Parliament, my lord, in view of Navtej Johar, my lord, and other judgments, my lord. There are specific provisions where discrimination is prohibited and is criminalized. I'll take your lordships to the, my lord, scheme and architecture of the Transgender Act. There is no stigma. The limited question is whether right to marry can be prayed for as a social institution by way of a judicial adjudication before this honorable court. Rather than, my lord, taking this matter any further, if your lordships are convinced that this is possibly a subject which may better, my lord, be left to the choice of the parliament, which is the law, my lord, if need be, I'll assist your lordship with that law. And the subject is such that your lordships may not be in a position to conceive of variety of situations which may arise and which will have to be taken care of. Lord, mere declaration that they have a right would be, my lord, begging the question. If they have a right, how the rights would be regulated? How variety of problems will be solved? And I'll give examples, my lord, which only parliament can take care of. Now, my lord, kindly consider, my lord, pre-56, marriages used to take place between heterosexual persons, my lord. conventional man, conventional woman. There was no recognition except societal acceptance. Correct, Manoj? Once it gained societal acceptance, in Hindus at least, it came to be codified in 1956 by way of a Hindu Marriage Act. The social status which it gets. Now, my lord, the moment any right which was pre-existing even without recognition by law is recognized, it is also regulated. And then there is no absolute right to marry even today between heterosexual couples. And why I say this? A man has to be 21 years and a woman has to be 18 years, meaning thereby the law prescribes when to marry. The autonomy goes. You just can't walk out of that institution. Law regulates even that on what grounds you can have judicial separation and on what ground you can have divorce. So how to separate is also a legislatively regulated provision. Even the codified law amongst heterosexuals protect the privacy of man and a woman inside the bedroom. But there are certain provisions where there is an intrusion to privacy rights also. For example, importance is a ground for divorce. That is something very, very private and personal between the two human beings. But then, if it is a case of divorce, you will have to come out and prove it. So your privacy is breached. The substance of my submission, which I will elaborate, is that once a legislative recognition is given to a particular form of union, it comes with it several regulatory provisions. The heart of Special Marriage Act, and I'll show that, is a recognition of marriage between a conventional man and a conventional woman. Your lordships need not, Lord, write, because I have, Lord, in that page 3, my lord, I have, my lord, written them. Second, the request, my lord, and I will demonstrate, my lord, more effectively. The request ultimately is that you please rewrite to suit our situation, which can be done by the parliament. I am not, my lord, opposed to the situation or some regulation coming into place. By whom is the question? And that rewriting would not be possible this also, your lordships need not, my lord, invest, my lord, time or energy, my lord, in writing it. This rewriting is not permissible, not only on the ground that the courts would not rewrite the law or say what the law should have been, but the thing which we are now seeking to achieve, the petitioners are seeking to achieve, was consciously omitted in Special Marriage Act. That is one more reason it cannot be read into it. I'll, my lord, make that submission good. So, my lord, your lordship's exercise would be constrained, my lord, by 4 fundamental principles. One, the court will not change the character of the law. And the character, your lordship will have to examine from the entire architecture of the act. Read with all allied statutes and the history which preceded enactment of the Special Act, Special Marriage Act. Second constraint would be the court cannot substitute the legislative intent which is otherwise manifest. And third, your lordships will not, my lord, read words of larger amplitude in place of words of smaller amplitude, namely, person is a word of larger amplitude in place of male and female.